And from the reading of the first judgment itself, it appears, that that was a case where the only question was whether against an interlocutory order, an appeal could be filed, a revision could be filed, or Article 226, 227 could be entertained. So it's
in the context of PC Act. In the PC,
there was no issue of any civil proceedings arising in that. There was no issue equally, my lords, what should be done with the interim orders. Of course, it appears that in the course of arguments, the aspect of delay, my lords, which nobody can deny, my lord, that proceedings are getting delayed in the high courts, especially in some high courts, my lord, like the Allahabad High Court and Patna High Court and so on. And the delays
the judges also were, that was what was weighing with them, that otherwise, stays just continue for decades to an end, particularly in the larger high courts.
And sometimes the delays are on account of the fact that the accused person will get an interim order and that continues. So they take advantage of it. The trials get frustrated, witnesses, long time lapse, the memories of the witnesses may fade. And in some cases, the respondents, the state is the culprit, they don't file affidavits promptly. And sometimes also, especially in the courts which I've mentioned, it is systemic fault. So,
150. The judges, it's in
fault itself could be for more than one reason, because there are 160 vacant posts in the High Court of Allahabad and only 90 judges.
His filing is enormous.
Filing is enormous. Matters don't get listed sometimes, and sometimes when they're listed, the judges are overloaded with work.
And this is
150
of course,
cases.
Allahabad, the problem is magnified.
Yes.
But the same issue, brother, just so was saying in Karnataka, I know that same issue in the larger high courts like Mumbai, and not the fault of judges, or for that matter, the litigant, because if there are 200 matters on board every day, 150 matters, 200 matters, and you have to write some reasons, give some, order which shows deliberation, application of mind, impossible for the entire board to be completed.
And Allahabad is compounded by the strikes. The lawyers, I have the secretary, Nitin Sharma is here, who is instrumental in filing. In fact, my lord, a very sad episode happened. And this goes back a long time, my lord. Justice Mishra and Justice Mittal is aware, my lord. The VC Mishra.
Oh, yes.
8 days, my lord.
Absolutely.
So for months together, the strikes used to go on and at a drop of hat.
No longer, actually. I don't think after 2000 and...
Chief Justice Sodhi, my lord, was the person who, despite so many judgments, because I don't know why the lawyers adopt this trade unionism tool.
5 days.
10,000 matters.
So it's not that once a while it happens. It happens quite frequently and regularly.
Dvedi, what is to be done then? What is the solution? Because if a judge grants a stay in a 482, they virtually means that nothing is going to come up in the next.
Look, the
maybe
first
for-
question which perhaps the Lordship will have to look into is, do we find a solution, my Lord, which is creates
Worse
a
than.
greater problem, which is worse than the disease?
Because it results in one more round again.
No, we have to create in every discipline civil revisions, appeals, and tax, and a separate bench which will consider now the extension of same amount of time, and the court says in resurfacing, give reasons while extending, which daily means not that both sides have to be heard. It's not like that we not able to take up, then we say extend it till the next day automatically. So, and that can happen in any court, not even in this court, it can happen. There matters for some reason, some important matter is going on, other matters are not taken up. Your Lordship normally asks not any extension required, it's extended in the normal course. So the judges are not to be blamed, they are making their best efforts, not in the difficult circumstances.
Granted interim relief after it was argued prima facie, you see.
Yes.
So when it comes up for extension, even if it's another bench, it's a principle of judicial respect for the fact that even assuming the stay was granted by another bench, it has applied its mind.
Yes. So the question, that's one important question, or do we come out with some formula, etc., which in this manner results in a vacation of a stay order with application of mind. And what is this formula? Is automatic. Neither the Supreme Court is applying its mind, because this is a kind of a judicial legislation. Automatic vacating for all cases, for all times. So because of this, the court is not, this court is not applying its mind to the facts of this case, that particular case, and High Court is also not applying. And in the second resurfacing which followed, this court directs the magistrates that you have to implement this, proceed.
But in some states, there are contempt petitions filed against the honorable judges. Because of the direction that it is the responsibility of the concerned learned judge to proceed. Some litigants, in Punjab, Haryana, in 3 or 4 states, contempt petitions are filed joining the honorable judges by name, the judges who were to conduct trial. So I join my learned friend, the solution perhaps is more severe than the disease. So we need to find out a solution, but this definitely is not the solution.
So I submit that this automatic reservation is no solution, neither practically nor on a legal plane.
What do you have to say about Article 226(3)?
Now, that's what the first question is, that Article 226 is a basic feature of the Constitution. If 226(3) is to be applied, then it will have to be tested whether that can be done. If Article 226 is part of the basic structure which this court has repeatedly held, it is. So it cannot be taken away, it cannot be whittled down. Neither by constitutional amendment, this is something like Indira Gandhi's case, where now by constitutional amendment, you are deciding that it will get automatically vacated. So who is applying the mind? It's interference with the process of judicial review. So if challenged, it will be liable to be struck down. But the High Courts, in some cases which we have cited, have therefore said that this is direct. They took another route. In Bombay High Court has also taken that view.
Yeah. And
Madras High Court
this provision came in by the 44th Amendment.
Yes. So I think that's the best solution, to leave it as directory. Otherwise, we will have to amend the petition and question 226(3) as ultra-virus. 368 cannot be used to bring in a provision of this nature. But in a way, the direction in Asia resurfacing goes much beyond Article 226(3). 226(3) says that upon the making of an application by the other side to vacate, if then it is not decided in 15 days. Here it is not required. The other side has to just sleep over for 6 months. You get vacated.
Technically, even if it's ex parte, after 6 months, the state would be vacated.
Vacated. In many cases, it has happened. That's why in the second case, this court went ahead logically to direct the magistrates not to proceed, implement.
Judgments are there before lordship, my lord. Perhaps, my lord, this may also be, my lord, necessary for lordships to consider in this, my lord, with the constitution bench, whether 226(3) is mandatory or directory, because there are diverse opinions among the various high courts, my lord. All those judgments are also there before lordship by way of a compilation file by me. I'll place them.
That will result in widening of the
That's
scope.
not the
my lord.
question.
No, maybe, but that will be a relevant thing also.
Possibly that's not the question, my lord, right now, 226(3).
Then we'll have to come with a petition questioning the validity of 226.
No, that's an interpretation of 226(3).
No, mere interpretation. Then we'll like to challenge the validity of.
Why should we go in?
But if it is to be interpreted, then it is directory.
Yes. And the high courts have given good reasons, my lord. 2 high courts have given good reasons.
solution रहता है problem create Sorry.
Vision before the amendment, that is in the footnote to this SCC EBC copy. If you have the red book with you, you have this red one. The earlier provision is in the footnote. It's very good. It gives all the footnotes. Mr. Dwivedi can read it from this book. It's at page 186. The earlier provision said that if you have not...
Petition
Yeah,
for the
just read it.
redress of any injury referred to in subclause B or C of clause 1 shall be entertained if any other remedy for such redress, that's alternate remedy, or under law for time being in force.
4 and 5.
Now see 4 and 5. 4 and 5.
No interim order shall, whether by way of injunction or stay or in any other manner, shall be made on in any proceedings relating to a petition under clause 1 unless copies of such petition and of all documents in support of plea for such interim order are furnished to the party against whom such petition is filed or proposed to be filed. Opportunity is given such party to be heard in the, that's fine, my lord.
Now see how 5 was. 5 was very carefully
Yes.
framed.
The High Court may dispense with the requirements of subclauses A, B, or
And
of
make.
clause,
and
of
make an
clause
interim.
4 and make an interim order in writing that it is necessary so to do for preventing any loss being caused to the petitioner, which cannot be adequately compensated in money, but any such interim order shall, if it is not vacated earlier, cease to have effect on the expiry of the period of 14 days from the date on which it is made, unless the said requirements have been complied with before the expiry of that period and High Court has continued the operation of the interim order. So that's,
This will not pose any problem.
Yeah.
The amendment, if your lordship sees, which is now there,
See, this amendment will apply only when interim relief is granted without
Without
furnishing copy and
furnishing
without hearing.
without it.
So therefore, if there is a notice issued, or in some high court's practices to serve state in advance,
Yes,
this will not apply at all.
this will not.
If copy is given and notice is served,
Served.
then this will not apply.
Yes.
Hardly significant. Will apply in
We
very
can,
limited
yeah,
cases.
so we can,
We don't need to go into it. Going to 226(3), Lord, in this matter. It operates in a different way on
And
different.
in a very limited
conditions.
cases, it will apply.
Yes.
because once A and B is complied with, then there is no question of an automatic
In high
vacation.
courts, in most
Then,
high courts,
I'll tell you, Lord, I would submit before your lordships why it's not necessary. Asia resurfacing essentially concentrates on stay of trials. Stay of trials would arise either in 482 or other jurisdictions.
227.
227, not in 226.
26.
But 226, my lord, we would be taking support, my lord, to substantiate other submissions. Just to say, my lord, that first, it's a part of the constitution. Here, it's a judicial continuing mandamus. Second, there is at least a requirement of an aggrieved party applying for vacating the stay. Here,
Automatic, without.
person who is not vigilant enough and sits for 6 months, he is put to premium by getting the stay against him vacated. He has to do nothing except being negligent, to put it, my lord, a little harshly. So that's the position. So 226 may perhaps not, my lord, require your lordship's attention in this matter.
The other way around.
not the copies are served in advance on the state councils,
Absolutely.
except in private disputes. Otherwise, their state councils are always served. And they have an opportunity of being heard. It's other matter that the state government advocates may not be having instructions, etc. So they get time alerts.
Anything in particular that you would like to add?
Only 2 or 3 things.
No, I have not stated.
All right, we will hear you. All right.
Right.
So,
I'll not take more.
how would you like to formulate the submission then, Mr. Dwivedi?
But I have 7 points.
7 points, all right.
Yes.
Just tell us. 1 second.
The judgments I have mentioned in my written submission, but I will not be
Correct.
taking your lordship through it. The propositions are all well settled and well known to your lordships. First is that this direction amounts to judicial.
Which is that volume, Mr. Dwivedi, your written submissions?
Separate volume.
So,
Separate folder, there's a.
Separate volume.
It's a separate volume. High Court bar.
yes.
They were allowed to intervene in the High Court. My lords, and
Correct.
the first submission is that this direction of automatic vacation is laying down of a general norm,
Direction for,
automatic vacation of interim order lays down a general norm, and therefore it is in the nature of judicial legislation. And this court, Lord, does not engage in judicial legislation.
yes.
In the same-sex matter, my lord, the lordships have elaborated. I don't need to, my lords. The second submission, my lord, that Article 226 is a part of the basic structure of the Constitution. And it can neither be shut out or nor whittled down either by constitutional amendment or by legislation and ought not to be shut out or whittled down in exercise of powers under Article 141 and 142. This is also because, my lord, the High Court,
This is the third point or the second?
third point,
Third point.
is part of the same point, my
All
lord.
right.
This is because the High Court enjoys a high constitutional status and it's not subordinate, my lord, to the Supreme Court. This also, my lord, has been held in several judgments. So merely because, my lord, there is a problem arising, that doesn't mean that the power of the High Court should be curtailed. And there should be any kind of a general direction that even if you have not applied, even if you have not vacated, we are saying it will stand vacated. And even we will not apply our mind, it will get automatically vacated.
Yes.
So the third point, therefore, is that the automatic vacation is neither hinged on application of mind by the High Court nor by the Supreme Court. An application of mind is the essence of judicial decision making. Without which the decision would be